All right, good morning, everybody. It is May 13th, 2021 at 9:03 a.m. and this is a regularly scheduled meeting of the Oil Conservation Commission. I'm Adrienne Sandoval. I am chair of the Oil Conservation Commission and director of the Oil Conservation Division. Also with me today, Commissioner Bloom, would you please introduce yourself?
Yes, thank you, Madam Chair. Greg Bloom. I am the designate of Commissioner of Public Lands, Stephanie Garcia Richard.
Thank you. In addition, we have counsel to the commission, Chris Moander, and commission clerk, Maureen Davidson. First item on the agenda is approval of the agenda, but before we do that, I believe we have a couple changes to the agenda. I believe we will be hearing case number 21744, the status conference, which is currently agenda item number 5. I believe we will be hearing that as agenda item number 4. And then agenda item number 4, case number 15855, that one will be heard following case number 21744. So we're swapping those items on the agenda. Just to confirm, Mr. Moander, is agenda item number 6, we're still slated to do that one?
What I'm going to recommend based on the conversations that have taken place is I'm going to recommend the commission vote to table that item, and we will circle back to that once I've completed some training and done some other items so I can provide the commission its required sunshine law training at a later date.
Okay. So I think, is there a motion to modify the agenda?
Chair, I move to modify the agenda by hearing.
I'm sorry, I can't hear Mr.
I can't
Bloom.
either.
Closer here. Can you hear me better now?
Yes.
Okay. Fortunately, I'm so close to my computer, I can't really see the screen. Let me try this again. Madam Chair, I move to modify the agenda by moving de novo case number 21744 ahead of case 15855 and striking the sunshine law opening meetings training from the agenda for today to be done at a future commission meeting.
So a point of order on that, the parliamentary procedure for this would be to table item number 6.
I move to table.
I couldn't hear that, sorry.
I can hear it. Yeah.
Okay, I move to table agenda item number 6.
I second the motion for the updated agenda. Mr. Moander, would you do a roll call vote, please?
Yes, I will. Commissioner Bloom.
Approved.
And Madam Chair.
Approved.
Motion passes unanimous.
Thank you. Next item on the agenda is approval of the April 15th, 2021 meeting minutes. Commissioner Bloom, have you reviewed the minutes and do you have any modifications?
Madam Chair, yes, I have reviewed the minutes and I have no modifications.
Great, I have reviewed the minutes and I have no modifications. Is there a motion to adopt the April 15th, 2021 minutes?
I'm trying to adopt the.
I'm sorry, I didn't hear that.
Let me stop and try and call in.
Okay.
Yeah. Hold on a moment. Does not seem to be helping. Oh my goodness. Oh my goodness. Oh my goodness. Oh my goodness.
Commissioner Bloom, you can only have one, either your phone or the laptop going because they're actually feeding off of each other, and that's why we're getting the feedback.
Let me log back in and call in and see if that fixes it. Hold on.
Okay.
It's a pain.
All right. Maybe this will be better. Looks like you're trying to talk, but I can't hear you.
I'm still not getting audio either.
Can you hear me?
Yeah,
Does that sound okay now?
it does at the moment.
Okay.
Yes, I have clear audio as well.
Okay, very good.
All
Everything was
right.
working great yesterday, and then today, yeah, not so much. All right, so I believe I was moving to adopt the minutes from the April meeting.
Correct. I second that motion to adopt the minutes. Mr. Moander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom
Approved.
and Madam Chair.
Approved.
Motion is unanimous and passes.
Awesome. All right, moving into the status conference in de novo case number 21744. Mr. Padilla and Mr. Savage, are we able to hear both of you?
Good morning, Madam Chair. This is Darren Savage.
Good morning. Mr. Padilla, I think you might be muted.
How's that?
Perfect.
Okay. I lost you temporarily there when Commissioner Bloom lost everything. So, but anyway, what I want to say is thank you for accommodating my schedule this morning and moving us to the front.
No problem. All right, well, I will give each of you an opportunity to provide the commission with an update, starting with Mr. Padilla.
Madam Chair and Commissioner Bloom, Mr. Savage and I had a discussion yesterday about how we should proceed. And frankly, we may be filing motions. I'm not sure. I don't have any plan right now, but we both need some time to evaluate whether or not motions are appropriate. And I think the commission should give us a deadline for submitting and filing motions ahead of a scheduled hearing. I don't have a complete indication from my client as to availability for the de novo hearing. I know that they have problems, and I've had to move some division hearings in August, but I think July or September would work. Mr. Savage has some thoughts about going back to the division, but I don't think that would be appropriate. I think the commission's ruling is that they would get a de novo hearing. Cimarex would. But he can speak to that, I'm sure.
Okay, thank you. Mr. Savage, would you like to provide an update? And then Commissioner Bloom, we can ask any questions either of us may have.
Yes, good morning. Cimarex submitted its final well proposal with all the criteria for that proposal on April 29th, or sent it out April 29th. We would like 30 days to before we file any applications, and it looks like Memorial Day hits in there, so we were looking at possibly June 1st to file a competing application. We appreciate that the process provided a mechanism for Cimarex to move forward to a position prior to the harm, and it was able to address the harm. We would respond to any motion that was, we would like the opportunity to respond to any motion that was submitted. I don't know how much you want me to go into the question of the best forum for any kind of competing application, but I'd be glad to talk about that briefly if you want.
Sure, if you want to just provide brief update on that, or what your thoughts are on that.
Okay, so, yeah, last night I was looking again at the case, Property Tax Department versus Molly Corps. It's a Supreme Court case, and you know, I kind of feel that under these circumstances, there is a proper procedure to go back to the division to have the case heard. But based on this case, it seems to me like it turns on. Well, one of the things I would be concerned about, you know, I have an obligation to protect the long-term interests of Cimarex, and I'm a little concerned that since Colgate has suggested it may challenge the decision in district court, we would want a proceeding that is not vulnerable to any kind of challenge. We'd want to, if Cimarex was fortunate enough to prevail in the end, we would want a decision secure from challenge. According to the Molly Corps Court, you can go back and have a relitigation, providing that the order is considered invalid versus valid. And under the circumstances of this case, because Cimarex did not fulfill its statutory requirements for a proper application, I believe that there's grounds to invalidate the order, and I believe that would allow a return to the division. If the order stands as it is without being invalidated, it would be viewed as a valid order, and I believe that would be vulnerable to challenge based on collateral attack type issues, type arguments. That's the concern that I would have. So in that case, I would agree with Mr. Padilla that you would need to move forward to the de novo hearing before the commission under those circumstances.
Okay. Mr. Bloom, do you have any questions for either party?
Madam Chair, I do not at this time. If you have some questions you would like to ask first, please go ahead.
Mr. Savage, so Mr. Padilla mentioned potentially scheduling the de novo hearing either in July or September. Do you have any thoughts on that?
I would be agreeable to September. I talked to my client, and they talked about August, but I think they would be happy with September if August was not available.
Okay, thank you. All right, I don't have any other questions.
Madam Chair, Mr. Melander, I'm wondering how we get at the question or a decision around whether we push this back to the division or have a de novo hearing at the commission.
So in responding to that, and I probably do have a question that may come out of this, it sounds to me that what I'm hearing from Mr. Savage is that even if we get this set for de novo, there may be motions filed in the interim, at least from Mr. Savage, I suspect would be the party or the council filing these, to invalidate the order, which would then render the de novo hearing at least moot for the short term. Is that correct, Mr. Savage?
Mr. Melander, I believe that would be a proper procedure and pathway.
Okay.
So
it sounds like there needs to be, there needs to be a briefing cycle here of some sort. Madam Chair, have you put in detailed scheduling orders on cases similar to this before? This is where I will plead a little bit of institutional ignorance.
I have not,
Okay.
at least not in my tenure.
Okay.
not to say there hasn't been before my tenure, but
Sure. Well, because I'm thinking here, I mean, there are all sorts of deadlines. I mean, they're not anywhere near as onerous as rulemaking, but if there needs to be some, I mean, I guess this would fall into at least a temporary dispositive motion. It sounds like putting in some deadlines for that, for the scheduled hearing out in September, would give enough time to get those motions filed. It also preserves the ability, if a de novo hearing is where this whole matter is headed, to put in a small scheduling order with the deadlines based out of the regulations. So that way the parties have they'll have that fallback position, assuming the matter doesn't end up back at the division. So I think putting in, motion deadline, I mean, 2-week response, 2-week reply, and then set it probably for July for the motion hearing. That seems to be the route to take at this point. And then at that point, if the decision's made one way or the other with the case, and it happens to go to de novo, then we can slap on I'll have it prepared in advance, some draft scheduling order to make sure the parties are up to speed and the commission's satisfied.
I mean, I think that would make it the cleanest, whether we've done it in the past or not. It at least lays out the expectations and the timelines very clearly.
I agree, Madam Chair.
And I think
Okay.
this follows a procedure, if I may, Commissioner. If it follows a procedure that the OCD has adopted for contested cases where pre-hearing order is issued with deadlines.
Thank you.
That is correct, Mr. Padilla. I'm not going to rattle off the citations, but I got the regs in front of me now, and those are the deadlines that would end up in some sort of scheduling order. So it would be consistent with the regulations.
Okay, so sort of taking that into account, Commissioner Bloom, does September for the de novo here tentatively, well, I guess schedule it in September for the de novo hearing, assuming we get to that point. And then July for the motions hearing. And then if we plan on that, then we can work backwards from the July date.
Sure, that sounds good.
So July, our hearing date is, I think it's the 8th. July 8th is a regularly scheduled OCC hearing. So let's see, I'm just thinking, working backwards, we would want responses. Mr. Molander, how early do we typically want responses? I'm sort of thinking by like the 2nd at least.
So when would what day are we agreeing for, or are you setting for the motion, like the actual motion deadline?
That's what I'm trying to work backwards to.
Oh, from the July hearing.
Yeah, if we started the July 8th date, we need to have responses in, my thought would be by the 2nd.
If you give me just a second, and I'll tell you, I do prefer giving the parties about 2 weeks for responsive pleadings, just because I know what happens if they're put under more than that. So or under less time, it's not as appealing for the outcomes. So let me see here. So you said July 8th is, so July 1. So a reply would be due on the 24th of June, response due on the 10th, and that would set a motion deadline for 2 weeks from today, the 27th.
Okay, sorry, say that again. Motion deadline is May 27th?
Yes, that's when the motions would need to be filed. And then responses would be due on June 10th. Wait, did I do that right? No, I went too far. My apologies. July 1.
It
Sorry,
seems
everyone.
like,
Well, I guess it depends on when we want I mean, how much time the commission actually wants to be able to, do you want these provided or the replies filed a week before to give you time?
I mean, that would be helpful.
Okay, so then if we work back from the July 1st, so that would be responses or reply is July 1st. Response would be 17th of June, and motion deadline would be June 3rd.
Okay. Commissioner Bloom, does that make sense to you?
Mr. Melander, can you say those dates one more time?
I'm no good at math. What are you trying to do to me? July
Anybody-
1st is reply. June 17th is response. And June 3rd is motion.
And the motion hearing on July 8th. Okay.
That way everyone's got ample time. No one's getting shorted here. And the commission will have the necessary time to review the pleadings.
Yes, this looks good to me. Thank you.
Do we need to make a motion on that, Mr. Melander?
Yeah, let's go ahead and adopt these, and I will prepare an order so that way we've got it in the record.
Madam Chair, could I ask one question about the proposed filing of the pooling applications? Would it be appropriate to be able to file those in June and have them available for the commission to decide what to do with that?
I mean, that's sort of going to hinge on what we do with these motions hearings, but you're just saying have it.
Have it
Yes.
available, and if we need to dismiss it, we will dismiss it, and, you know, if we go forward, we go forward.
I'm fine with that. I mean, what about having those available by that June 3rd date
That would be great.
with the
yes.
motions?
I'm agreeable to that.
Mr. Padilla, do those dates work for you?
Those dates were fine for me. I think we can work around that fairly easy.
Okay. All right.
What did we add on June 3rd motion deadline, and what else is happening that day?
For Cimarex to submit their pooling application. Is there a motion?
Yes, make a motion here, and would that include the Cimarex submitting its pooling application by June 3rd?
I think, yeah, we want to include that in there.
I would recommend that.
Okay. Run through the other dates. Madam Chair, in de novo case 21744, I move that on June 3rd, we have a motions deadline, and Cimarex will submit the pooling application by that date. That responses to the motions will be due June 17th. Replies will be due July 1st. A motion hearing will be held at our regular July 8th meeting, and the de novo hearing will be scheduled for our September 16th hearing.
I second that motion. Mr. Moander, would you please do a roll call vote?
Yes, Madam Chair. Commissioner Bloom. And Madam Chair.
Approve.
Motion passes unanimously.
All right. Well, it sounds like Mr. P and Mr. Savage, we will be seeing you again in July.
Thank you, Madam Chair. Thank you, everybody.
Thank you.
Thank you.
Thanks again for rescheduling the docket. Thank you.
No problem. Thank you.
I'll get to the mediation now.
Madam Chair, I think at this point, the commission can take a recess until we have Mr. Rankin join. Or is he?
I
Oh, he's
believe
here.
he just joined us.
Well, look at that.
Mr. Rankin, are you there?
I am here. I appreciate the commission's accommodating my vaccination schedule this morning.
We fixed all the schedules this morning.
Thank you.
Ms. Hardy, are you there?
I am here. Can you hear me?
Yes.
Okay, thank you.
All right, great. Well, we will move on to case number 15855, a motions hearing for the application of Delaware Energy LLC to revoke the injection authority granted under SWD 1680 for the Alpha SWD number 1 operated by Alpha SWD LLC. I think in this situation, I'll let both of you provide sort of a brief update to the commission, and then we will move forward from there. Please keep in mind that we have read the order and the information, and so we are already familiar with that. Mr. Rankin, would you proceed?
I'm happy to go first, Madam Chair. However, I defer to Ms. Hardy since it was her motion, I think, but I'm happy
Sorry.
to give my input on how things should stand, but I think properly, maybe Ms. Hardy should go first.
No, I agreed. Sorry about that. Ms. Hardy, would you please start off?
Sure. Thank you, Madam Chair. So at this point, I think where we are is that the district court issued its order on the issue of whether the division had jurisdiction under the Oil and Gas Act to determine that an administrative injection permit was issued in violation of the division's regulations, because the permit had been issued prior to the 15-day expiration period after it was submitted. So that's the issue that the district court addressed in the appeal, and the district court decided that the division did have jurisdiction over Delaware's application to revoke Alpha's permit. And page 8, paragraph 3 of the district court's order states that the division got it right. Alpha's application for a permit was granted without a hearing. Delaware had no choice but to file an application to revoke Alpha's permit. The division then held the hearing, and after review of the evidence, revoked the permit. There has been no dispute that the permit was issued prematurely. After Alpha's hearing, and I think they mean permit, was revoked and it sought a de novo review from the commission, that is where the errors in procedure occurred. So that's what the district court decided. So now I think here we are back before the commission for a de novo hearing, or one to be set, on Delaware's application to revoke Alpha's permit, because that hearing was never held. The commission had decided the case based on a lack of jurisdiction of the division. The commission had also asked the parties to brief issues related to standing of Delaware to apply to revoke Alpha's permit, and that issue was fully briefed by the parties in November of 2018. So it's been quite a while, but I think that that's an issue that has not been addressed by the district court or the commission. And so I think at this point, Alpha would ask that the commission consider the motions that were filed regarding dismissal of Delaware's application based on Delaware's lack of standing. And I can address the standing issue in our argument, unless you would like for me to hold off on doing that until you hear from Mr. Rankin.
Yeah, let's hold off on that for a moment and let Mr. Rankin.
Thank you.
Good morning, Madam Chair, Commissioners. Adam Rankin appearing with the law firm of Holland and Hart on behalf of Delaware Energy LLC. I agree with what Ms. Hardy read from the district court's order that the division got it right. I think that is correct. And then I think I disagree about what needs to happen next. I don't believe that the commission needs to revisit Delaware's application to revoke injection order 1680 at this point. I believe that that with the rescission of the existing order B, I think that we can go back and decide, what the next step would be. And I think it would be, as Ms. Hardy was relating, prior to the point where the procedures started to go awry, which is essentially where the division left off, which is at the revocation of that injection authority. The question then is, where do we go from there? And I think what we have said before, and what we think that the correct next step would be to remand the competing applications before the division for a hearing on each of the individual, injection authority applications, before the division. I think that would be the proper next step, assuming that the commission, finds that Delaware has standing to make its arguments on the authority to inject. So I'm happy to address that motion. I do believe it's the district court, while it was not directly before the district court, indicates very clearly, where it would come out if that issue were to be appealed again. I do believe that there's standing, but happy to go into that argument. But procedurally, I think the proper course would be for the commission to remand the issue or the matters both to the division, for the division to hear the competing applications on injection. I think the division is probably more fairly equipped to hear competing applications along those lines. And then at that point, if there's a dispute over the division's resolution of that, then the parties can appeal that to the commission. I will say that, if it's helpful to the commission, I do believe the commission has authority to hear the competing applications directly. Under 1915-420 subpart B, the director may direct that the commission can hear a matter directly without having it to go before the division itself. However, I think that, in the nature of competing cases, the division is probably better equipped to hear such matters in the first instance, especially these cases in which neither one has been heard, and there's perhaps some still factual matters that would be better suited for a presentation at the division level.
Madam Chair, I've got a question that I want to put out there for the parties, if that's okay. So one of the issues that I'm struggling with a little here, and I know the commission is aware of this issue, is the difference between dismissing a de novo application and then remand, because my understanding of the procedural posture at the division level is that the division doesn't actually in and of itself have anything left to do. It's that if the parties need to do something at the division level, if it were to end up back there, in other words, like the case was effectively completed but not all the way through the regulation, like all the regulations and what was in the order. So if we were to remand it, doesn't that require at least one of the parties or both to take action, which is not usually how remands operate?
I agree, Mr. Moander. I think, well, the issue I see is that Delaware had filed its application to revoke Alpha's permit, which was granted. And then Alpha has this application for de novo hearing that has never been decided. So to me, it seems that if the cases were remanded back to the division, it would require at the least dismissal of Delaware's application to revoke the permit if we're going to go back and have a hearing on the actual injection permits. And then procedurally, I think those permits have been basically, I think Delaware's has been suspended or canceled, depending on how you look at it. And I think there's a dispute about that. So how we go back and have a hearing on the injection permits would be, I think, a procedural, well, I guess I'm not sure exactly how that would work.
Okay. And Mr. Rankin?
Yeah, so I think because the district court has voided order 14484B and E, I believe that, in my view, it would essentially leave the original commission order, which I should have reviewed this. I'm sorry I hadn't, but I believe it was upholding the division, original division decision, which was to rescind the Alpha's injection authority. So I think where this ought to go is it ought to go back to where it should have been, as the district court has laid out. In fact, I think the district court provides a roadmap for the commission to follow here on page 3 of their order. And what it says here is that prior to considering Alpha's competing C108 application, the division should have required Alpha to provide notice to Delaware Energy or notify Delaware Energy itself of Alpha's pending application. So that's what should have happened, and it didn't. So by first sentence, second sentence, the division should not have approved Administrative Order SWD 1680 without first affording Delaware Energy an opportunity to protest Alpha's later filed C108 application. So I think where we are is that I think the district court is giving direction to the commission to restart at this point so that Delaware can properly protest Alpha's pending, what should be now a pending C108 application. Having permitted Delaware to make that protest, then the parties can then proceed at the division level to have a competing hearings on their proposed injection. I believe that the district court has laid out a framework and a pathway here for the parties and the commission to help resolve these competing applications, and that's what is provided in that paragraph on page 3. So I think to Mr. Moander's question, what with a remand, I think that if there's a motion that should be filed by Delaware to affect this this result, I think that I'm happy to file it. But I think that it's within the authority of the commission to, in the effort to resolve this dispute, to remand the matter to the division level pursuant to the direction given by the district court, for there to be, for Delaware to be provided the opportunity to protest Alpha's application, and then for the division to hear what then would be two pending SWD applications.
Okay. That makes, I mean, what I've been hung up on is conventionally when something gets remanded, there's some level of instruction to that administrative body or court saying, here's what you have to do as a court or adjudicatory body next, or here are your next steps. And that isn't quite how this order is written. And so because a remand in this case sort of leaves the case sitting on the division's desk until and unless a party takes some sort of action. And that's what I'm trying to clarify here for purposes, because I looked at this and there's a big distinction between a dismissal and a remand. And in this instance, because there's the necessity of a party taking action, if this is, we'll say, remanded in quotes to the division, that just seems like an odd outcome in a way to me. And I wanted to hear how the parties viewed that, because I've never had I've not had court orders that didn't give lockstep marching orders on what needs to get done next. So that's what I wanted to clarify.
Yeah, thank you, Mr. Miranda. I think, in my view, the directions we've been given are in that paragraph on page 3, which is, essentially to start at the point where the division should not have approved Alpha's application and should have permitted Delaware the opportunity to protest. I think we should go back to that point, allow Delaware to protest, and then we would have competing applications for injection at the division. I think that's the direction here from the district court.
Thank you, Mr. Rankin.
Commissioner Bloom, do you have any questions for the parties?
Madam Chair, not at this time.
I don't either. So, Mr. Moander, I mean, in this situation, and maybe you can help in terms of the terminology here, whether it's a remand or a dismissal, but it doesn't appear that the commission has the jurisdiction to hear the de novo application.
Madam Chair, I think that is right. And one of the issues in here is that, but for Alpha's application, Delaware does not file one in this case. And so my suggestion is that if the commission didn't have jurisdiction to hear Alpha's application, then I think that it really does impact the remainder of the case because everything stems from that application. And so if the commission doesn't have jurisdiction, then, and this is where I am a little stuck on this. I think from what I'm seeing and hearing the parties and my own research, it would seem proper to dismiss this matter and remand it to the division at this point for further proceedings consistent with the order. Because otherwise we're going to end up with a bifurcated case where things will not operate properly again. And I think the court was clear. The error happened once the commission took or assumed jurisdiction. And the remedy here is to rewind things back to that point and get everything done correctly at the division level. So a dismissal of the applications of both parties with a remand to the division consistent with the court's order.
Madam Chair, Mr. Morander, would it work for me, and I would welcome any from the attorneys here as well, work for me to move to dismiss this matter and remand it to the division for further proceedings pursuant to the court's order?
I think that's proper.
I would second that motion.
And,
Mr. Moander.
Oh, no, well, do you guys want to select, or does the commission wish to hear from the parties any further on this?
Yes, let me, Madam Chair, if you could permit me, Mr. Rankin, any thoughts on that?
No, I think that's the right course. I think the only thing that might be helpful in any order issuing from the commission would be some clarification on maybe timing. In other words, I think my assumption would be that upon the dismissal and remand, I think the clock on Delaware's time to protest, I think should be set. And I don't know the dates. I'm sorry, I should double check that. But I think there were a few days left when the initial administrative order approving Alpha's injection authority was granted. So I think what I would propose is in any commission order that the clock would be set for a date certain when the division resumes authority over these cases, and that Delaware be afforded the opportunity to make its protest, just so it's clear, and then the division can proceed according to a request to have the cases heard at the division level.
We could say, Mr. Rankin, remand this to the division for further proceedings pursuant to the court's order, so that Delaware Energy can make its protest by X date at the division.
Yeah, so I'm sorry I don't have that information in front of me. I'd have to double check the timeframes in there. I believe it was on the order of 4 days or so. Seeing if I could figure it out real quick.
Yeah, that's info I wasn't preparing for either, now that you mention it, Mr. Rankin.
I think it's 6. Well, I believe it would be, if you're looking at the date that Alpha submitted its final information, is June 19th of 2017.
Mm-hmm.
And the division issued the permit on June 28th.
Okay, that would be.
And this is why lawyers go to law school, right?
That's
I
right.
mean, I know that joke has been beaten to death, but it's not wrong.
It's not wrong.
Yeah,
So would that be 6 days?
I believe that would be right.
I think that's right.
I'm getting 6 days. I think it is.
Okay, and that would be 6 days from now.
So conventionally, when time is calculated tomorrow for filings and pleadings, tomorrow is day 1. So today is sort of a freebie in that sense. So the clock, tomorrow is day 1. So if that's the case, then that would put, and we're under, let's see, we're under 10 days for this. So weekends are not, wait, where's my civil procedure on that one? I forgot that, like which way that rule works, because if I remember right, you don't get weekends if it's under 10 days.
And I don't know if that's, so this would be governed by the notice and injection rule, right? So I don't know if
Oh,
it's
you're right.
right. So I don't know if it specifies calendar days or business days.
Well, let's find out.
We'll make sure our protest is submitted tomorrow.
That's the safe thing to do.
Yeah, here's what I'll do. Because I know everyone's busy and I'm not going to chew up your time. I will confirm all this stuff and be in touch with you guys this afternoon about the, I'll reference where I'm finding, where all the deadlines are coming from. And I'll make sure that that's properly taken care of. If there's a problem, we'll be able to work that out, I think, between me and the parties, unless someone thinks that's not going to happen. Does that sound amenable?
That sounds reasonable to me.
Yeah, thank you.
I did have one request, and that would be to avoid further confusion. I think it would be helpful if the order remanding to the division clarified that Delaware's application to revoke Alpha's permit is also dismissed, right?
Yes, no, that
Okay,
will be. So I think the intention of the commission, and the commissioners are more than welcome to correct me, is to sort of wipe the slate clean at this level and get it back to where things were working properly. And just for the sake of cleanliness and structure.
May I make one point there, I guess. I just want to be clear, though, that the intent is that Alpha's authority to inject will have been revoked, because that in order to get it back to where I think the district court intended, there would be no authority to inject on the part of Alpha. And I guess if I understand Ms. Hardy correctly, she's suggesting that the division's order may stand, and we go back and have a hearing at the division level on the two competing applications to inject.
Yeah, that'll be, and that's what I was getting at about party action, is that in effect, what I see this doing, or the commission action resulting in, is that everything stands as it was just prior to any commission filings by the parties with the commission. And that's where it stands at that point in time. I realize that's, it is suboptimal and it can be a little harsh in that sense, but that's the only way to clear out the sort of the taint here, I think.
So Ms. Hardy, if you would repeat that then, you're suggesting that we simultaneously dismiss Delaware's motion to dismiss? I'm sorry, I got lost on that one.
Sorry, no, so the case, the whole case began when Delaware filed an application to revoke Alpha's permit, right, which the division granted. And then Alpha filed for a de novo hearing with the commission. So if the commission is dismissing Alpha's de novo hearing application, and we're going back to the division to have a hearing on the competing injection permits, then I would think that Delaware's application would also have to be dismissed. They can protest, according to the commission's ruling, the injection permit, but if we're back at square one, then we're back at square one. And I think that
so it would be we would dismiss Delaware's application to revoke Alpha's permit to inject.
Right, which is why Delaware would protest, right, the permit. Right, because if the permit's already revoked, then there's no hearing on revoking the permit.
I think that makes sense. Just back to that point that Mr. Randall was back in the division. We started new. Okay.
I'm sorry, Commissioner Bloom, I didn't hear that last comment.
Sorry. That gets us back to what Mr. Miranda was suggesting, that we get this back to the division and can begin anew.
I guess at this point, do we have a motion?
I think I got it. Mr. Miranda, jump in if I blow this or anyone. All right, Madam Chair, I move to dismiss this matter and remand it to the division for further proceedings pursuant to the court's order so that Delaware Energy can make its protest by, we didn't get the date.
6 days.
Yeah, okay, make its protest within 6 days at the division and dismiss Delaware Energy's application to revoke Alpha's permit to inject.
I second that. Mr. Moander, would you do a roll call vote, please?
Yes, Commissioner Bloom,
Approved.
Madam Chair,
Approved.
the motion passes unanimously. As to the parties, I will be working on this quickly. This will be a project for today so we can get this done.
Thank you. Agenda item number 6, as we discussed earlier, was tabled for a later date. Agenda item number 7, is there any update on pending litigation?
Yes, Madam Chair, the case I've been calling the Marker Appeal, the Court of Appeals issued its opinion on April 19th, 2021. I believe I forwarded that to everybody. The court found no error on the part of the commission, and so that that's the end of the case, and we have no other litigation pending at this time.
Thank you. Is there any other business in front of the commission? All right, then our next meeting will be on June 4th for a motions hearing associated with the rulemaking hearing on June 9th and June 10th during an extended regularly scheduled June meeting. With that, it's 10:03 and we will adjourn. Thank you, everybody.
Thank you, Madam Chair.